Discovery is the engine driving civil litigation. It's how facts are unearthed and cases are built. But when a party decides to obstruct that process by destroying documents or refusing to answer questions, the engine stalls. To get the engine moving again, the rules of court provide an enforcement mechanism. Rule 29 acts as the teeth of this litigation engine, ensuring discovery obligations cannot be ignored with impunity. The central tension within this rule lies in distinguishing between two distinct behaviors: mere recalcitrance against opposing counsel and true defiance. In civil procedure, true defiance is measured strictly by one metric: disobedience of a direct judicial order. Refusing to cooperate with a lawyer is a friction. Refusing a judge is a violation. Because of this distinction, Rule 29 contains a strict hierarchy of sanctions.
Penalties escalate proportionally, starting from the simple payment of expenses and attorney's fees all the way up to the complete dismissal of a case. We are going to conduct a strict sequential audit of this hierarchy, moving from Section 1 through Section 6. This sequential audit will expose the exact procedural triggers and the specific traps that bar examiners consistently use to test a candidate's grasp of civil procedure. Understanding this specific escalation matrix is often the difference between securing passing marks and failing the remedial law exam entirely. We begin with Section 1. Consider a deponent who simply refuses to answer a single question during an oral deposition or a written interrogatory. A common misconception is that this merits immediate punishment. The actual immediate remedy is to file a motion to compel an answer. It is not a contempt citation. This diagram maps the process using the acronym CAE: compel an answer, and if unjust, pay expenses.
The exception is substantial justification. If the court finds a legally sound reason to refuse the question, no expenses or attorney's fees are awarded. The mechanical requirement is that the proponent must apply to the proper court, specifically the court of the place where the deposition is being taken, to acquire that order. Examiners frequently test a specific procedural trap here. Does the deposition completely halt? The rule explicitly states the examination may either be completed on other matters or adjourned while the order is sought. A mere refusal to answer opposing counsel does not trigger immediate sanctions. Judicial intervention must occur first to bridge the gap between recalcitrance and defiance. Once a judge formally issues an order, the rules escalate. Disobeying that direct judicial command moves the situation directly into Section 2. Section 2 dictates that if a party or witness refuses to be sworn in or refuses to answer any question after being directed to do so by the court, that refusal is now contempt of court. The RADC acronym, refusal to answer after a direction, equals contempt. The critical exception: a witness cannot be held in contempt if shielded by a constitutional privilege, like the right against self-incrimination. The constitutional shield holds. Examiners will often present a fact pattern where a deposition officer, such as a notary public, attempts to cite a recalcitrant declarant for contempt. Recognizing that the officer lacks this power is a mandatory issue spot. Only the court possesses the power to cite for contempt. This strict requirement for judicial authority separates the mild compulsion of Section 1 from the punitive severity of Section 2. Section 3 addresses what happens when a party disobeys specific discovery orders, beyond just answering questions, such as an order to produce documents under Rule 27, or submit to a physical or mental examination under Rule 28. The court is empowered to impose severe, case-dispositive sanctions. It can order that designated facts be taken as established against the disobedient party, or strike out their pleadings entirely. The court can go even further. It may dismiss the action, render a judgment by default, or issue an order directing the arrest of the disobedient party. The acronym EFSDA tracks this escalating power: establish facts, forbid evidence, strike out, default, and arrest. But a vital exception exists. A court cannot issue an order of arrest for a refusal to submit to a physical or mental examination. This immunity applies exclusively to medical exams. If a party defies a court order to produce a contract or financial ledger, directing their arrest remains a highly valid option for the judge. This distinction exists because the law balances the court's absolute need for procedural compliance with the uncompromising protection of a person's bodily autonomy. Section 4 governs requests for admission under Rule 26. This occurs when a party is asked to admit a fact or a document's genuineness, and they serve a sworn denial in response. The penalty triggers specifically when the requesting party goes to trial and successfully proves that the denied fact was actually true, or the denied document was actually genuine. The acronym DPE, a sworn denial that is proven true later, results in expenses charged for proving that fact. Two exceptions exist: if there were legally good reasons for the denial, or if the admission was of no substantial importance to the case. Not confuse a failure to reply with an active sworn denial. Failing to reply results in an implied admission, meaning the fact doesn't need to be proven at all. Section 4 only activates when an active denial forces the requesting party to do the work of proving it. This mechanic penalizes parties who force unnecessary, costly trials over facts that should have been admitted during discovery. Section 5 covers total procedural abdication. The first trigger is a party willfully failing to appear before the officer for their own deposition after receiving proper notice. The alternate trigger is a complete failure to serve answers to written interrogatories submitted under Rule 25. Upon motion and notice, the court is authorized to immediately strike out their pleadings, dismiss the action entirely, or enter a default judgment. The acronym WFSD tracks this absolute failure. Willful failure results in strikeout, default, or dismissal. Unlike Section 1, because the party completely ignored the process, opposing counsel does not need a prior court order to seek these severe sanctions. Total ghosting of discovery obligations removes a party's right to sequential warnings. If a litigant completely ignores the rules, the court is justified in immediately terminating the case. Finally, Section 6 addresses the limits of these penalties when litigating against the state. The general rule is absolute. Expenses and attorney's fees cannot be imposed upon the Republic of the Philippines. We map this with the acronym EAR. Expenses and attorney's fees are exempt for the Republic. There are 0 exceptions to this financial immunity within Rule 29. The state's purse is strictly protected from monetary sanctions. But there is a crucial bar trap here. While the Republic is financially immune, it is not procedurally immune. If the government commits severe discovery violations as a plaintiff, the judge can still dismiss its civil complaint. You must explicitly differentiate between financial immunity from costs and procedural immunity from case dispositive sanctions. Confusing the two is a fatal exam error. To synthesize this into a rapid-fire decision tree for the exam, ask these questions in order. Did the party show up but refuse to answer a specific question? That maps to Section 1. Apply for an order to compel. Did a judge explicitly order them to answer and they still refused? That maps directly to Section 2. The sanction is now contempt of court. Did they completely ghost the deposition or ignore the written interrogatories? That maps to Section 5. Move immediately to strike pleadings or enter default. Was the disobedience specifically regarding a court-ordered physical or mental exam? That maps to Section 3. The court can dismiss the case, but it cannot order an arrest. Finally, is the violating party the Republic of the Philippines? That maps to Section 6. The case can be dismissed, but no financial penalties can be assessed. Rule 29 is a tactical weapon. It ensures that the machinery of civil procedure cannot be stalled by an uncooperative litigant. It provides a systematic, graduated response to obstruction, forcing the absolute truth out into the light in real practice. Mastering this mechanical escalation separates rote memorization from true procedural mastery, giving practitioners the ultimate edge.